Hello and welcome to today's AHAM webinar, CRCS Exam Preparation. It is now my pleasure to turn the floor over to Maria Briceño Burnett. Maria, when you're ready, floor is all yours.
Welcome, everyone. My name is Maria Briceño Burnett, and I am the National Certification Chair for the CRS and CCT exams. Today's webinar will focus on the CRCS exam preparation for credit and collections. This session is recorded and available on demand. If you didn't know whether you're planning on taking any of the AHAM certification examinations, preparing for the future, or need the education to enhance your job performance, statistically, those who have participated in our webinars have a higher exam pass rate than those who did not. That will make you want to take the exam. More good news. During the summer certification webinar series, the electronic certification manuals are included with the price of the exam. Paper copies of the CRCS CCT study guides are available at half price, $50. That is an absolute bargain. But to get that bargain, this program will only run through September 30th, 2022. So sign up soon. Today's presenters are Marina Hines, Andy Politz, Lori Hayden, and Heather Rickarn. So we're going to start off today's session with a quick poll. We want to know why you're joining the webinar today. So we want to know whether you're joining the webinar today for exam preparation or refreshing knowledge and keeping up with current events. So we're going to take a brief pause and allow you to answer that poll question. Right now, most of you are saying for refreshing and keeping up with current events. All right, so it looks like about 26% of you are taking the, joining our webinar today for exam preparation, and 74% of you are taking it to refresh your knowledge and keeping up with current events. Well, thank you very much. At this time, I will turn it over to Heather Rickarn to review federal agencies and regulations.
Good morning or afternoon, depending on where you are. My name is Heather Rickarn, and I will be starting off with discussing federal regulations and federal agencies. So I hope you are all excited to get started. As we go through and begin to talk about our federal agencies and regulations, we have to remember that this can play a really significant role in those healthcare changes that we deal with day to day. And so within that, we have to understand the different departments that can play into that. We have the Department of Health and Human Services and its many operating divisions that exist out there. We also have to remember the intricacies of the Office of Inspector General, or OIG. As we go through, we'll describe the roles of CMS, of the OIG. We're going to look at many of the federal regulations that affect healthcare and really kind of dig into what is their impact that can be in there. And finishing up with that federal regulations area, we'll go into the Joint Commission. Now, our group today said this would be a fantastic kind of pair-in as we talk about those credit and collections, because many of those regulations do impact that collection process. So that's why we've chosen to kind of begin our discussion today by looking at those components. Now, as we look at the different federal agencies that exist out there, there are really two main governing bodies that you are going to need to know of for your exam. And as you are preparing your materials for that, you're going to maybe want to use your note cards to create some great flashcards of some of these different acronyms so that you can be very aware of what they are interchangeably with their title. So the two main governing bodies that we have are CMS and OIG. CMS stands for the Centers for Medicare and Medicaid Services. So make sure that you are understanding what they are in that order. You also have the Office of Inspector General, or OIG. And so each of these are going to play pretty significant roles in the operations of our revenue cycle. Also under the Department of Health and Human Services, and you're going to see this referred to as DHS, DHHS, or HHS, depending on what you're looking at in your manual. There are 11 different operating divisions within that. And so we want to look at each of these. We have the National Institute of Health, or NIH. We have the Food and Drug Administration, or the FDA. We have the Centers for Disease Control and Prevention, CDC. We have the Agencies for Toxic Substance and Disease Registry, or the ATSDR. We have Indian Health Services, or IHS. We have the Health Resources and Services Administration. We have the Substance Abuse and Mental Health Services Administration, SAMHSA. We have the Agency for Healthcare Research and Quality, AHRQ. Centers for Medicare and Medicaid Services, CMS. The Administration for Children and Family, ACF. And the Administration for Common Living, ACL. Within that, we want to just make sure that you understand each of those 11 operating divisions. If you're preparing for the exam, know that there are 11 existing out there. And so great some tips and tricks for creating those note cards as you're studying along. So let's expand off of that. When we talk about those federal agencies, we have CMS and OIG, as we had mentioned in there. Now, CMS is really combining the oversight of the Medicare program, known as Title 18, as well as the Medicaid program, known as Title 19. Now, Medicare is really that federal portion of administration where the Medicaid is looking at a partnership between the federal and state interactions. You also have pieces within the state Children's Health Insurance Program, or CHIP, known as Title 21, and the Health Insurance Marketplace. All of these are really looking at those quality improvement components as well. Now, as we're talking about CMS, we want to remember that CMS is really there to develop those rules, the regulations, and things that are going to govern both the Medicare and Medicaid program. They also will contract with entities to administer the benefits for the various regions across the United States. And so as you're preparing, know the different titles. Know Medicare is 18, Medicaid is 19, CHIP is looking at 21. So as you're going through, some kind of helpful tips and tricks. Now, CMS administers those quality improvement organization programs to monitor and improve our utilization. Not only that, they're there to really look at our quality of care for Medicare beneficiaries. Now, in contrast with those QIOs, they're there to review all of those written qualified service complaints that come through. They're going to look at it. They're going to determine what are the standards of care that should be given, as well as saying what should be rendered to that patient as part of that interaction. They're going to look at the results of that review and submit everything back to CMS. And so they're kind of the go-to people to do those investigations. Now, finally, we want to talk about the Office of an Inspector General, or the OIG. And they're there to really look at protecting the integrity of health and human services programs. Big word there as you're preparing for that exam, looking at the integrity of the programs. And they're there to also look at the health and welfare of the beneficiaries of those within the program. Now, the OIG has a major role in doing the investigation of both fraud and abuse. And so as you are preparing, make sure you have a very clear understanding between what is fraud and what is abuse. So that's another great example of something that you could use for your note card process. Trying to advance my slides here. There we go. We also want to look at those different areas of regulations because these can play an impact in how we do our job in patient access and credit and collections, all of those different pieces. And so some of the laws that your manual are going to highlight, or those regulations are talking about, our patient rights. We're going to talk about administrative simplification. We're going to talk about the Affordable Care Act. We'll go into anti-fraud and abuse, telephone consumer protection. We'll talk at length about credit and collections, and you'll see a lot of that in our presentation today, as well as patient anti-dumping and performance improvement standards. Now, all of these different federal regulations that are going to impact our way of doing things within the industry. And so you'll want to make sure that you have a good understanding. Now, one way to help those that are preparing for the exam, I like acronyms or things like that to try and help me through. So I was like, okay, remember PAT, so P-A-A-T, and then C-P-P just kind of stuck in my head. So if you're trying to think of tips and tricks, that might be one of them for you. Now, as we look at patient rights, this is really an integral part in what we do. Now, the Patient Bill of Rights was really created back in 1970 by the American Hospital Association. And there, they wanted to make sure that they had clear expectations for what the patient and their families can kind of expect in their treatment process during those health situations. And so, as we progressed through our laws and regulations, the Bill of Rights was really replaced with a brochure that we titled today as the Patient Care Partnership. Now, according to that brochure, during a hospital stay, patients have things that they can expect, such as that high quality of hospital care, that things are going to be clean, they're going to be safe within their environment, that they have good involvement or interaction in their care, that their information is going to be kept private or protected, that they can have help with leaving the hospital, as well as help with kind of billing those claims. Now, when we look at all of these kind of patient rights, we have to remember that the two kind of critical ones there are the right to privacy, so all of your information is kept private, as well as the security of that health information. We also have that right to participate in our treatment. We have the ability to ask questions and say yes or no during that process. So some other great things to kind of help kind of prepare for that exam, so to speak. Here we go. Now, as we look at the rights to privacy and security of health information, there's a lot of concern, especially with today where we have the advancements of the internet and we have all kinds of different electronic forms of engaging. And so the Health and Human Services issued out these expectations of privacy and security known as the rules under HIPAA. Now, as you're preparing for the exam, HIPAA is the Health Information Portability and Accountability Act. So it's 2 A's, not 2 P's, as you're going through. When we look at those HIPAA privacy rules, they're really creating those national standards for protection of your medical records and making sure that no one has inappropriate access to it. Now, we do have standards for safe and accurate exchange of information, and so those standards are going to show up here on your slide, basically allowing that patient to have control over that health information. They're able to kind of set guidelines of who can have access, when is it going to be released, when do we relinquish that access. we go ahead and establish those safeguards in place, make sure that we can ensure that their information isn't just going out anywhere. We want to have those safeguards. If a violation happens, how do we hold that organization accountable, both on the civil and the criminal penalties that can be imposed there, as well as making sure we can strike that balance between having that responsibility of disclosure, but also making sure that that data is kept private for that patient. Our next slide here, if we can get it to advance, there we go. We then go into looking at some of those additional pieces within the standards. Now, this is so that the patient can make really informed decisions on what kind of care they want or how that care is going to be done. They also can make distinctions on how reimbursement is going to be done for the services that they are receiving. And so within that, they are making those informed decisions as they're having those cases. So how is their information being used? How is it being disclosed? What are the limits that are out there? Making sure that they can obtain copies of their records and make changes or corrections when necessary, and really empowering them to have control over the information that they have themselves. This is really in a place for the patient to feel that they have ownership in their information, that they can make informed decisions on what needs to be done. They are going to really help in limiting that release as part of that. Which leads us into our discussion of PHI, or Protected Health Information, another fantastic card that you can use to understand one of those sometimes hard acronyms out there. Now, PHI is what we say are individually identifiable pieces of information to that patient. It can include any data that can be used individually, so one piece of it, or in combination that would help you in identifying that patient. Now, the administrative simplification rules have had an impact on healthcare as well, and so we have to understand that it's this information, but it can also be through the ERA, through our remittance advice, all of those different pieces. So elements of the PHI that we have to be aware of: name, date of birth, address, phone number, email address, social security number, medical record number, employer information, name and address, relative information, name and address, any certificate numbers that may go with anything. So example, pacemaker serial numbers, photographs and fingerprints are all pieces that are considered protected for that patient. And so we just have to kind of understand those different elements of PHI as you're preparing for the exam. You could easily have, is this PHI or not? And then list out each one, and then on the back say yes or no, to kind of help you in preparing and remembering those many, many things. Now, as we talk about PHI, and it can come through our ERAs, our remittance advice, all of those different pieces, we have to remember too that some of the payers may not have standard information requirements as far as order and things like that. And so PHI still applies in those instances as well. And so we have to make sure that we are being very careful and very protective of that information so things don't get inappropriately disclosed. The last piece here that's within my discussion is where we talk about our right to participate in our treatment decisions, which is really critical for those patients. Now, the Patient Self-Determination Act, or the PSDA, what that was is it was passed to help ensure that patients understand their rights to participate in the decision-making of their health care. It basically is giving them the ability to say yes or no. Now, the Act really details out advance directives, our statements of what our wishes are, our living wills, our healthcare power of attorneys, our do not resuscitate orders, all of these different components that are critical to our care and what we want. So as we're looking at those advance directives, when we talk about a living will, what is this? It's a document that is going to specify what I want for treatment, what I don't want for treatment as the patient. It's really outlining those decisions about the future while also making sure that we're doing so when the patient is alert and able to make those decisions of sound mind. Now, when we talk about healthcare power of attorneys, we also have durable power of attorneys, which basically is designating someone, an individual, like a healthcare surrogate, an agent, a proxy, one of those, to make decisions on behalf of that patient when they are unable to do so. Now, the last one that is on here is our DNR, or Do Not Resuscitate Order. And so within that, that is really documenting out when I don't want heroic measures such as CPR to occur. So we're looking at interventions that could be intrusive and where I, the patient, can then say, I'm not comfortable with having that occur. So as you're looking at the Patient Self-Determination Act, remember that it's involving advance directives, and those examples are those living wills, the power of attorneys, and our do not resuscitate orders. Next, then, we're going to actually transfer into Andy, who is going to be talking about our affordable care. Andy?
All right. Thank you, Heather. Okay, yes, we're going to be talking about affordable care here. But first, I did want to give a bit of a disclaimer. None of the presenters today are accepting any compensation from the index card manufacturers of North America or the big index card lobby. So I just want to put that out there right now because we are probably going to keep making that recommendation over and over again today. Heather said a bunch of times that we want to be looking at taking all of these acronyms, especially all these big list items, and putting them into index cards, and that's absolutely some great advice. So I'm going to keep parroting that, and affordable care is a great place to start. So we're going to be talking about the Patient Protection and Affordable Care Act. That's its big full name, PPACA. Might have also heard it called the Affordable Care Act. So another acronym built into it, you could see PPACA or potentially ACA, so you can write both of those down. But this is actually a really significant act, and it's one of the largest overhauls to the regulatory environment in healthcare for a good number of years. Okay. And what we're going to really boil this down to is the two main goals of the act. You can see them listed here on the screen. The first, it wants to decrease the number of uninsured Americans, and it wants to reduce the overall cost of health care. There's a couple ways it's going to try to do that. There's some things, mandates, subsidies, tax credits to employers, and actually some individuals, and all of these are set to try to increase the coverage rate, and again, lowering the overall cost of health care in the United States. Insurance companies are required to cover all applicants, and they have to offer the same rate regardless of pre-existing conditions or gender. So some of the things that are identified when we're talking about the Affordable Care Act here. Next, we're going to talk about fraud and abuse, something that has, again, significant impact in healthcare and could have serious ramifications if not paid attention to. First, we're going to have a couple definitions. Fraud. the intentional or illegal deception or misrepresentation made for the purpose of personal gain or to harm or manipulate another person or organization. All right, let's see some examples of that. Incorrect reporting of diagnoses, procedure codes, things like that in order to try to maximize or increase payments and reimbursements. Billing for services that were not performed. That's a great example right there. That is textbook fraud. So if you're asking for definition somewhere, that's a good example you can kind of jump back to kind of remember that. Adjusting the claims or altering them to receive payments. And kind of related what I was talking about earlier, the little joke I was trying to make, accepting kickbacks. Again, no money is being received from big index cards, so we're on the up and up here. But that's an example of something that could fall into the realm of fraud. And then waiving any kind of like deductible or coinsurance amounts. These are all things that could roll up and be used as examples of fraud. Right. So looking at abuse, that's incidents or practices of healthcare workers that, although not usually considered fraudulent, so it starts off by saying, abuse, it's not usually fraud, but it's inconsistent with accepted sound practices. All right, and a couple examples of this. Excessive use of technology. If they're performing a lot of services that require technology that you really could get away with without using, that's really not necessary, that's an example of possibly abuse. Let's see, increasing charges to Medicare beneficiaries, but not to other patients. Medicare is not a fan of that. They're going to find you if you do that, but that's an example of abuse. And then just also rolling into that, some abuse of authority, privacy, confidentiality, or what they refer to as duty to care. So these are some things that can roll up into the abuse category here. So for everyone taking the exam and you're using this for your preparation, definitely want to know the definitions and probably a couple examples of each of those. That's going to help you out when you're sitting for exam time. All right, then we're going to talk about the False Claims Act. Unlike some of the other acts that we get thrown at us, this one, the name kind of says it all, so it's a little easier to remember. This just prohibits making false statements, basically to get paid, submitting a false claim to the government in order to receive payment. We're going to keep it real simple, boil it down to that. And that's what you want to remember when you're studying there. So that's what covers sort of that realm of fraud and abuse. The False Claims Act really focuses on finding those records that you might be submitting to try to get those, and what they're called, false or fraudulent claims paid. All right. And then there are some administrative sanctions. If CMS, there's another acronyms there, identifies any of this fraudulent or abusive behavior, sanctions can be taken. You can see that it can include revocation of the provider number. So basically, your standing in the Medicare program could be put in jeopardy, and that is huge for a lot of hospitals out there. Suspension of provider payments, or civil monetary penalties, also sometimes known as CMPs. So this is something that is taken very seriously. The OIG, investigates fraud and abuse claims. This is something that is at the top of Medicare's radar, and it's part of how they're trying to control costs of healthcare by limiting instances of fraud and abuse. So any instances that they do see, will see a lot of those sanctions coming through. Okay, next we're going to move on to a list of some more acts and regulations. So this is a place where you definitely want to get your note cards ready because we have a lot of acronyms going on here. So we'll start talking about some of these. But this is a good point too. I just do want to remind everybody, my exam takers again, that all these regulations that we're talking about right now here are very involved with credit and collections. But if you're looking in your exam manual and you're studying, it might not necessarily show up in the credit and collections section. A lot of this is covered under the federal agencies and regulations. So I don't want anybody sleeping on that out there thinking that you can skip over this section or that it's not necessarily related to the other three sections, since those get talked about a lot. Definitely make sure that you're looking at these regulations. These will show up repeatedly and prominently in any of the exams that you will take. So, word to the wise, my little warning I want to give everybody here. All right. Well, the first one we got here on the list is the Telephone Consumer Protection Act, or the TCPA. This works to restrict telephone solicitations, use of automated telephone equipment. So it talks about, prohibiting use of auto dialers without consent. It addresses the use of cell phones, and it actually also limits pre-recorded voice messages or text or SMS messages, or it even does specify fax machine use in there as well. So that's the act that deals with all things kind of telephone and communication related when, especially in the healthcare arena, contacting our patients. All right, next is the Truth in Lending Act, also known as Regulation Z. This deals with how information is disclosed prior to an extension of credit. So under Regulation Z, like APR and finance charges, they have to be clearly identified, and they have to be provided to the consumer in like a written disclosure. There has to be something written given to them as well. Right, the Fair Credit Billing Act. Right. The Fair Credit Billing Act, it requires creditors to inform debtors of their rights and responsibilities. Sorry. So this one, sorry, tickle my throat here. Again, that's the important part to know, the purpose of what this act is. So for my test takers, you want to remember that. Our next item on the list, the Fair Credit Reporting Act, defines what information from consumer reports can be used. This is one that I've seen kind of confused. You can see them right next to each other on the list there, and they look very similar. There's one word difference there, but it does change the meaning pretty significantly. Like I said, the Fair Credit Reporting Act, it sets up how that consumer report information can be used. So the consumer has more knowledge and a little bit more rights to privacy and just understanding of how that information is being supplied. So the upside is Fair Credit Reporting Act has the words credit reporting in there. So if you can think of that as your consumer reports and tie that to your credit report, that might help you make the distinction between the two. Again, those are excellent flashcards. So I would recommend writing those down, making the note of those two especially. Okay. And then next we have the Equal Credit Opportunity Act, or the ECOA. And this, it prohibits discrimination, and it does that on the basis of race, color, religion, national origin, sex, marital status, age, or the receipt of public assistance. So it's important to remember that it prohibits discrimination relating to credit based on those elements. That sounds like a great multiple choice question or a which one doesn't fit type of question for an exam. So that seems like something you want to definitely add to that list. Make sure that those protected elements are present when you're doing your studying on the ECOA. All right, and I think that actually brings us up to our first knowledge check for today. So I'm actually going to turn this over to Maria, and she will lead us through this.
All right, thank you, Andy. But first, I would like to put in a plug for saving trees and not using paper flashcards. So there are many sites on the websites, and if you Google, you'll find some ones that are the most popular one that we like to use is cram.com. So you don't have to use paper flashcards, but you could use electronic flashcards, and they're very handy because not only are they electronic flashcards, but you can play different games and various ways of flipping back and forth the answers that can help you. They're also available to you on Android and iPhones. All right, so let's do our first poll check. The first question is the protection of consumers from inaccurate or unfair practices by insurers of open-ended credit is regulated by which of the following agencies? And if everyone could take a moment and answer that poll question, I'll briefly keep quiet for a moment while you all answer that question. Did we stump you? I'm not seeing anyone answering the poll question. All right, I'm seeing answers coming in right now. We have 50% the Fair Debt Collections Practices Act and 50% the Fair Credit Billing Act. So which one's going to win here? Right now we're at 41%, 58%. All right, the answer is C, Fair Credit Billing Act. 57% of you got that question correct. So let's turn it back over to Andy.
All right, thank you, Maria. All right, so jumping back in, we are going to talk about another act now. We just saw it actually on the previous knowledge check. It is the Fair Debt Collection Practices Act, also known as FDCPA. All right. And this came around as a result of debt collectors that were, they weren't being very nice when they were trying to collect debts. So they had some abusive collection practices, and that led to the creation of the FDCPA. All right, so this act, it puts limitations in place to protect the debtor, especially in terms of how they're being communicated and the information that's being gathered. It prevents debt collectors from using misleading information. So, calling and lying to a debtor, making false threats, things along those lines. These are things that can fall under the FDCPA. It also limits when a collector can contact a debtor. So the time frame it sets, and this is actually for the location of the debtor, since we do have crossing time zones here. Outside of 8 a.m. through 9 p.m., or if it's considered a place that is inconvenient to the consumer, and that would be obviously notified to the debt collector. So those are kind of times and situations where outside of those hours or outside of any reasonable request would be considered possibly an abusive practice. So it's setting up that time frame especially to know when you can contact in an effort to collect a debt. If the debt collector knows that the debtor has an attorney, they have to contact the attorney. Unless there's some sort of other previous consent given, communications have to go through the attorney if that's known to the collector. It also covers other elements as well. Say the debt collector is calling the debtor at their place of employment. If it is known, it's been communicated that the employer does not allow calls like that, then that is something that the collector is prohibited from doing. They won't be able to make calls when they're at that location. Their collection attempts have to occur somewhere else. And while we're talking about that, it's not on the slide, and I don't think it's actually in the exam or manual yet, but I did just want to point out that in November of last year, there's actually a new law or act that's come into place. It's Regulation F, and it provides some clarification on the Fair Debt and Collection Practices Act. I think AM actually had that mentioned in a webinar not too far back. But for everybody who wants to, I would just make sure you kind of, if this is for your own information and to stay up on current events, maybe look into that, because it does define some, or clarify some new elements, I guess, that were kind of covered under the FDCPA, but especially in terms of communications. It talks about using telephone calls, emails, text messages, so it provides some clarification on that. So I would recommend looking into that a little bit more if you're interested in it, or if it's something that's going to pertain to your area of work, just as a little bit extra understanding for what we're talking about here, some of these credit and collections regulations. Okay, next we are going to talk about EMTALA, the Emergency Medical Treatment and Active Labor Act. That looks like an exam question if I've ever seen one. So I would make note of that acronym. And like Maria said, we don't have to kill trees anymore. We can go use digital index cards and make note of that. But this is something you definitely want to know. It's also known as the Federal Anti-Dumping Statute. And this was brought about because there were concerns that hospitals weren't treating patients without insurance and even turfing them to other facilities or leaving them there without even notifying the other facility that they were sending them to. Some truly not great stuff was happening. So then EMTALA was brought along to kind of help with that. All right, so through EMTALA, there are requirements. A medical screening examination needs to be done. If there is any required stabilizing treatment, that needs to be done before a patient can be moved. And that kind of goes along with the next item here. There can be no transfers until that stabilizing treatment has been done. So Any registration staff is allowed to gather basic information from a patient that's seeking treatment, and they can ask questions about how they're going to pay after a medical screening exam. So before a medical screening exam, questions about how the patient's going to pay is prohibited. So if the patient's sitting there bleeding from the head and you're trying to figure out what their insurance is or how they're going to be paying, that's not your time. You need to wait until after any medical screening exam has been completed. This applies not just to emergency departments. It definitely has emergency in the title there, but it can also apply to any location on a hospital's campus, any patient in the facility, not just ED patients. So it's important to know, there are some other factors that can play into it, but the big things are what we have listed up there. It's, what is required by EMTALA, and that's your medical screening examination, your necessary stabilizing treatment, and restricting transfer until after that stabilizing treatment has been done. Okay. All right, talking about performance improvement now. Okay, the Clinical Laboratory Improvement Amendment, or CLIA, requires that all clinical laboratory services that are being furnished by Medicare, or to Medicare beneficiaries, they have to be performed at a provider who has a CLIA certificate. So basically, it's just like a certification that needs to be received in order for those services to be, done for Medicare beneficiaries. Okay. Important note there are state exemptions, and that is, I think, currently New York and Washington. And the reason that they're exempt from this is because they have other requirements in place that are actually more stringent than the CLIA. So that's why those two have their exceptions. It's not because it's the wild, wild west out there and they don't care if they're certified or not. It's because there's actually extra certification on top of what's required by CLIA. Okay, the Joint Commission, known as TJC, if you're keeping your acronyms up to date. This is a private agency, and its goals are to protect and improve the quality of care and the safety of care in patients in treatment facilities. The Joint Commission is used for accreditation purposes. CMS has them, allows them to go in and provide accreditation to hospitals. It performs inspections. It provides education on issues that could impact patient care, on things that could impact, patient safety or the safety of anybody in the facility. And it has standards that it uses to ensure this. Not all hospitals are accredited by the Joint Commission. Again, some have other agencies or even through the states which they can receive accreditation through. Because again, this is a private agency that CMS allows to provide accreditation to a lot of facilities with, but not all. It's not a requirement. The Joint Commission, it's going to conduct their audits for hospitals every 39 months, and for a lab every 2 years. Okay, those time frames are kind of important. Hospital, 39 months, lab every 2 years. The organization, they can perform their audits. So the Joint Commission can come in without advance notice, and this can be done, again, another time frame, as early as 9 to 30 months after its initial audit. And below are some areas where they can expect the Joint Commission to go through and perform some of their surveys. And a lot of this actually applies to patient access. But it can go in and it can look at distribution and discussion about advanced directives, which we talked about a little bit before. Patient rights and responsibilities, again, sounding familiar. Organizational ethics, the continuum of care, the management of environment of care, confidentiality, privacy, security, and communication. For those you might see again possibly in the access section with these agencies and regulations, you are going to see some bleed over. But I always think it's better to have more than less, especially when you're preparing for an exam. Okay, and that actually brings us to our next knowledge check. So Maria, I'm going to kick it back to you so you can read through what we're going to be asking now.
Well, thank you, Andy. Let's take a quick poll check. So if everyone could look towards the poll. Our next question is, under the Fair Debt Collection Practices Act, what is the time frame in which a debt collector can contact the debtor? Is it 8 a.m. and 9 p.m. in the debt collector's time zone, 9 a.m. and 8 p.m. in the debt collector's time zone, 8 a.m. and 9 p.m. in the debtor's time zone, and 9 a.m. to 8 p.m. in a debtor's time zone? I do see responses coming in right now. C is looking to be the front runner as far as the responses are concerned at 65%. So the correct answer is C, 8 a.m. and 9 p.m. in the debtor's time zone. I'm going to turn it over now to Lori Hayden, who's going to go over the credit and collections section.
Thank you, Maria, and thank you, Andy. Good morning, good afternoon, depending on your time zone. I'm going to be trying to make this as exciting as we can since it is credit and collection. Always a good time. Our objectives for this particular time is going to be, we're going to define the terms that are related to credit and collections, explain how the statute limitation affects collection efforts, identify the elements of an effective collection policy. You might want to remember that one. Describe typical self-pay options along with the advantages and disadvantages of those key options. Identify common types of bankruptcy and how they affect the collection process and possible outcomes. That one should be bolded as well. Identify the responsible party for a given scenario. Define the list advantages of a courtesy discharge. List common delays or stalls of third-party payers. Anyone in healthcare is going to be very familiar with that one. Identify common debt collection methods and practices. List the generally accepted accounting principles for the cashier's role. You might want to remember that one too. And describe common metrics related to the collections. We thought the credit and collection regulations were pretty important, so obviously it was included a second time on here for our slides. But just to re-review, the regulations include the TCPA, the Truth in Lending Act, Reg Z, Fair Credit Billing Act, Fair Credit Reporting Act, Equal Credit Opportunity, everything's delayed on me, and also the Fair Debt Collection Practices Act. I'm not going to go back through all of these as Andy did just complete all of this for you, and it does take some time on that one, but that is an excellent area to start reviewing prior to your exam because this seems to be a problem with a lot of test takers when it comes to this section. All righty. All right, Maria, it's back to you again. We have yet another knowledge check.
All right, so quickly, according to the Fair Debt Collections Practices Act, at what usual time may a debtor be called at home? Anytime before midnight, at the collector's discretion, any day except Sunday, or only between 8 a.m. and 9 p.m. unless prior approval has been obtained from the debtor. Please put your answers in the poll question, please. Thank you. So right now, it looks like everyone is answering D, only between 8 a.m. and 9 p.m. unless prior approval has been obtained by debtor. And you guessed it, that is the correct answer. So I'll turn it back over to you, Lori.
Thank you. Repetition is key here if you hadn't noticed that yet. All right, moving on down our line. And looks like it's stuck again. All righty, we've got some cool definitions for you out here. We've got charity care, indigent care, bad debt, and statute of limitations. For charity care, oh, excuse me. Our charity care is a very important one. Ordinarily for a charity care, it's something we aren't actually expecting any type of a reimbursement on that particular one. So that makes charity really easy, clear cut, clean, and to the point on that one. And next I have indigent care. Indigent care normally indicates it's an individual who homeless for the most part. We've got a homeless individual with indigent care, and that's another one which sometimes can end up being under charity and or roll over into a bad debt, pending a situation. And bad debt on that token as well is one we have tried and tried to collect. We aren't getting anywhere with this individual, and we just end up cutting our losses on that, and we turn it over to bad debt. Most facilities have a bad debt reserve, which they keep that just for situations of this. And our statute of limitations, that's always a fun one. Ordinarily, this particular situation is you've got a set timeline as which to try to collecting of a particular type of service and or a debt. And once that is exhausted, you no longer have the ability to do anything else with that part. All right. And we move on to number 26. We are close to home. Our effective collection policies. There are numerous collection policies on here, and I can assure you, you will be seeing this on the exam at some point, and it could be under the admissions part, or it could even be under a separate collections. Organizations should have a written collection policy in place just to ensure the staff knows what to follow and how to handle different procedures and situations. Obviously, as you see in front of you, there's several different processes and policies that will make up an effective collection policy. All the processes of an organization play the role in the patient's service. In result, it also comes down to the patient's final balances. Effective policies in place will limit the amount of money that we end up losing overall. So we've got admission policies, payment policies, follow-up policies, public relations, charity care, which includes the requirements and the different protocols just mentioned previously, a discount policy, practice of charging interest if that's applicable, contract amount implications, bad debt policies, determination, verification of responsible party, and process for handling any type of error and or complaints. Moving down the line, we have self-pay options. Everyone, I'm sure, is going to be pretty familiar with this. There's several different types of processes in which a patient can have. Ordinarily, these are presented at the beginning when a patient will come in prior to a large surgery or a pre-planned inpatient service, anything of that nature. You've got checks and cash, credit cards, HSA or health savings accounts, credit union funds, cash from the sale of assets, which is always a scary one, loan programs, money transfers, money orders, or extended payment plans. To touch on each of these, I'm going to kind of review some of your positives and your negatives surrounding this. An advantage for obtaining a credit card payment, you've got your immediate payment is in hand. You've got options of different payment plans on that, and you can receive payments over the phone if it is credit card based, and you also can get prior authorization to charge the card for particular payments, and also can do that on the interim. Now for the disadvantage, you've got additional costs of processing the credit cards. You've got some more paperwork like options you'll have deposit slips you've got to process through the banks, etc. Public relations, sometimes you've got patients out there that they agreed to a credit card. They're talking to their neighbor. Yeah, they agreed to take my credit card, but now they're charging me interest. So that's not always a real promising thing because you don't know your audience from time to time whenever they do that. It's nice and kind up front, but after the fact, it may not be as they're talking to their neighbors. And you've got additional workflow, of course, to continue following up with any type of the payments for a credit card if they're going to be paying monthly by credit card and continuing to follow that patient. And you've got extended payment plans can be offered if you've got other options that weren't exactly feasible for a patient. You've got payment plans, could be 3 monthly installments. You can set that up on most of your patient accounting systems nowadays, and those work same as cash. Excuse me. And of course, whenever you're dealing with anything with a credit card or taking out loans, you're dealing with finance charges that can be applied. Oh, looks like Maria is up again with one more knowledge check. Maria?
Yep. So everyone, our next question is, what is considered an uncollectible account resulting in extension of credit? Your responses are statute of limitations, charity care, indigent, or bad debt. Let's see what you have. Looks like answers are coming in right now. Looks like bad debt is running in front, followed by charity care. Bad debt looks like it's running away with the answer. And the answer is D, bad debt. Thank you for playing on that poll. I'll turn it back over to you, Lori.
Thank you. All right, this is always a fun one. Try to stay awake. We're getting close to the end now. This is regarding bankruptcy. We've got a Chapter 7, 11, involuntary, a Chapter 12, 13, and one that a lot of individuals do have problems with is the court ruling, whether something is discharged and or dismissed. Because the bankruptcy is a legal process when debts of an individual or a particular company exceed the assets, and presumably there is no reasonable hope of repaying something. This does require an attorney to do this, so the patient can't just walk into a facility and deem themselves bankrupt. It doesn't work that way. This is actually handled through the U.S. court system, and it's based on wherever the patient is living. Now, a Chapter 7, the first one, is applying to individuals or businesses that can't pay their debts based on incomes, except exempt property, which is defined by laws. The debtor's assets are then auctioned to satisfy credit claims. 70% of all bankruptcy claims are filed under Chapter 7. One we see pretty frequently on TV and we hear about is Chapter 11. It's a reorganization bankruptcy. It gives distressed businesses a reprieve from their creditors while they continue to work out some type of a payment plan. And it gives them about 3 months or so to kind of get their business pulled together so they are able to pay their debtors. Most Chapter 11 cases end up as 7, sadly, under a liquidation. This one I wasn't as familiar with. Involuntary is a debtor can be placed in involuntary under Chapter 7 or 11 if the debtor has 12 or more creditors. Yikes. 3 of which claims greater $5,000 each, and they're willing to force that issue. If fewer than 12 creditors, then only one creditor owed at least $10,000 is needed to force that bankruptcy. A little scary. Chapter 12. This is specifically designed for farmers and providers that only a family farmer with regular annual income may file a petition for relief. Only the debtor can file a petition under 12. And the last of these is Chapter 13. It's designated for individuals who want but are not currently able to pay their debts with regular income. Ordinarily, the court will put something together for them, and then they end up making regular payment plans through that, as opposed to actually bankrupting everything and having everything sold off to cover those. Something that you will be seeing on the test is the difference between a discharge and a dismissal. Discharge means this one has already gone to court It already has been ruled on, and this particular case, regardless of which chapter it is now listed as discharged, meaning the person is no longer liable for any of that. Those debts are now done. Either stuff is being sold, something of that nature. Now, the flip side of that is a dismissal. Dismissal is when the bankruptcy has been rejected by the court, and it's done when the debtor fails to show follow through on the filing process. They may not have provided all the documentation they needed. When they went to court, it could have been deemed they had assets to cover everything, so it was just dismissed from there. Whenever you do end up with the situation, you see that the particular bankruptcy has been dismissed as opposed to being discharged. These accounts can then be referred to a collection agency or any other type of litigation because the debtor is no longer protected under any of these bankruptcy laws. This just kind of gives you some step-by-step follow-through as to what actually happens. If you are in a patient accounting situation and you've got something that just came across your desk indicating this patient has filed bankruptcy, of course, you're going to flag the account. You suspend all collection efforts as long as this person is still under the bankruptcy protection, meaning this has been filed, they are working on this. You cease the contact, notify the collection agencies, and if it's been officially discharged, then you're going to forward that notice and any type of a notification of a payment if that has been deemed any type of a settlement. This is where I'm going to pause and I'm going to transition everything over to Marina. Thank you.
All right. Thank you, Lori. Thank you to everyone else. And I hope you guys are still awake because we only have a few more slides left. All right. So determining the responsible party. This is very important to be able to efficiently collect the balance. So everyone should understand who is responsible for each kind of account balance. So even when injuries are caused by negligence of another party, the adult patient is always the responsible party. In certain states, spouses are responsible for each other's debts incurred during the marriage, even if the marriage ends or the other spouse dies. Both parents are responsible for a minor patient, and parents may be jointly pursued or separately, even if divorced. If there's life-threatening emergencies, an authorization for a treatment is not necessary, and a lack of authorization does not relieve the responsible party of the financial obligations for services. Estates are responsible for outstanding debts for the deceased, and children and other relatives are not legally responsible. When a deceased notice is received, there are several steps that need to be taken. So you should check to see if there's a legitimate estate, and if it exists, then file the appropriate paperwork, or check the register of wills for an estate. Change the mailing address to the estate of, and if there is no estate and no other party assumes financial responsibility, then the balance should be written off. Courtesy discharge is also something that is made available at the facilities. It's when a patient can leave the hospital without going through the usual discharge formalities when the patient's financial considerations have been met. The patient is then billed later for any remaining responsibility. There are several advantages of the courtesy discharge. It improves the patient relationship with the hospital relationship with the patient. It also improves the traffic flow, which also reduces the need for additional staff at peak discharge times and allows for greater accuracy in billing. So I'm going to transition really quickly back to Maria for another knowledge check.
Thank you, Marina. So the next question really quickly is the Regulation Z is also known as what? Truth in Lending Act, Kennedy-Kassenbaum Act, EMTALA, or the Fair Credit Reporting Act? Please enter your answers in the poll section. So far, it looks like Truth in Lending Act is running the way with Fair and Credit Reporting Act coming in second right now. All right, the answer is Truth in Lending Act A, where 85% of you responded correctly. Marina, I'll turn it back over to you.
Thank you. All right, third-party stalls and delays. So a part of the revenue cycle process is trying to obtain information and payment from insurance companies. While doing so, insurance companies will try to stall or delay payments. So there are various reasons or ways that insurance companies will do this. You definitely will need to be familiar with them, one, for being able to navigate that process and work, and also for the exam. So they will say the bill has not been received, the COB or MSP problems, medical record review, incorrect information, and authorizations incomplete or missing, timely filing, or pre-existing conditions. So back to those flashcards, whether it's going to be paper or electronic, you definitely have one for these various reasons. And then debt collection in general. So in reviewing collection efforts, an organization has several options, whether to collect the debt in-house or to outsource it. So there are different things to consider depending on which option. When assigning accounts, they should be assigned by high dollars or organized by payer. Work lists can be put in place to organize the work. When preparing staff, ensure the staff is aware to have all pertinent information available when making calls, as well as documenting everything. Document, document, document. All right, hope you guys can hear me better now. When making collection calls, the primary objective is to request payment in full. When preparing for the call, review all transactions on the accounts, all notes, to make sure that you are prepared for that phone call. And make sure you are always willing to accept the minimum payment for the payment plan. A mini Miranda is also something to be aware of. This should be provided on in-house collection calls or statements mailed. This identified the attempt is to collect the debt, and any information obtained will be used for that purpose. If a third-party debt collector does not provide the debtor with the mini Miranda disclosure, it is a violation of the SDCPA. If you do not keep the account in-house, they can be sent to a third-party collection agency. The Medicare bad debt requirements indicate that there is an appropriate sequence of collection attempts before an account is referred. A statement notifying the guarantor of the intent to forward to a collection agency is needed. Sometimes the debt is to be filed a lawsuit against the debtor, which is done by a collection agency. There is a judgment also, which is a legally verified claim against the debtor, validated by the court. A legal right to collect a debt that can be used to obtain a lien. A lien is a recorded claim against real or personal property, typically arising out of debt. The creditor must be paid out of the proceeds of the sale if the property is sold. And then a tort liability is the liability for an injury or wrongdoing by one person to another, resulting from a breach of legal duty. So I'm going to transition back to Maria again for a final knowledge check. Or I'm sorry,
Okay.
not final.
Yeah, we're almost there. We're almost there. All right. So which type of skip is caused by a clerical error at the time of registration? Is it intentional, false, or unintentional? And if you could please start answering that in the poll question, please. Thank you. So it looks like so far unintentional is coming in first and false is coming in second. And the answer is unintentional, C. Thank you very much. Marina, I'm going to turn it back over to you.
All right, so that knowledge check was basically to gauge your knowledge ahead of time. So now we will go over the skip tracing. So a skip is a debtor who cannot be located by a creditor. Skip tracing can be very useful in the collection process, and as we've learned, there are three types of skips: intentional, unintentional, and false. An intentional skip is someone who avoids paying bills by changing his or her address and failing to provide a forwarding address, purposefully changing his or her name, or intentionally giving false information. An unintentional is someone who does move or change residence and does not notify or fails to notify the creditors. However, a forwarding address is typically provided. And then a false skip is caused by a clerical error at the time of registration, an incorrect address, zip code, or incomplete information. There are multiple resources for skip tracing: the patient counting system, if there are notes or document imaging, the post office, internet sites, credit reports, current or previous employers, neighbors, and or relatives. Another topic under the credit and collections section is the generally accepted accounting principles, so basically the cashier functions. It is a combination of standard and commonly accepted ways of recording and reporting accounting information. Several of these principles do apply specifically to cashier functions. So I would definitely make sure you are well aware of all of these and have these memorized to understand how they apply. So endorsing checks for deposit only, issuing receipts to customers for cash payments and depositing them the same day, using separate cash boxes for cash collected and petty cash, storing payments prior to deposit in a fireproof safe, maintaining a duplicate number receipt login and payment log, locking the cash drawer and not sharing passwords, and separating the cash functions. One person is responsible for collecting the cash, while another is responsible for depositing. And then last but not least is the metrics for the credit and collection section. For the exam, you will not need to calculate anything, but you should be familiar and know the actual formulas. So the average daily revenue is the average amount of revenue or charges generated each day over a specific time period. So it's the total revenue for charges for that period over the number of days in that period. And then the average days of revenue in accounts receivable is an estimate of time needed to collect the accounts receivable. It can be calculated for any period of time or for any component of AR. So it would need to be the accounts receivable at that specific time or for that department, and then over the average daily revenue. And I'm going to transition back to Maria for our final knowledge check.
All right, so our final knowledge check is, which of the following is not a GAAP cashier function? A, endorse checks with forward deposit only. B, maintain a duplicate number receipt and payment log. C, notify the collections department upon receipt of payment. Or D, segregate responsibilities like collection and deposit. It looks like everyone, 55% of you are answering C for notify the collection department upon receipt of payment. And it looks like segregate responsibilities like collection and deposit are coming in second. And it looks like we're running away with the correct answer, C, notify the collections department upon receipt of payment. All right, we have about 10, thank you all for answering that question. We have about 10 minutes left. Let's look in the question and answers if there's anything that we haven't answered. And it looks like we have a couple.
There's two out there. One of them was asking for that website again for the electronic flashcard.
Sure, and that's cram.com, C like cat, R like run, A like apple, M like Mary, cram.com. But that's not the only one. There are several others out there as well. Let's see, we answered that. It looks like we answered everything else. All right, so we have answered all the questions, it appears. So I'd like to close today's webinar. Thank you for joining the credit and collections training session today. It looks like we had about 357 attendees today. Next up in the summer webinar series is the Access webinar, which is scheduled for August the 10th. I would like to take this time to thank all of our speakers, Chelsea Carper, Heather Rickgarn, Marina Himes, Andrew Politz, and Lori Hayden. Thank you all and have a pleasant day.
Hey, Maria, really quick before we drop off, we had a couple more questions come in at the end. Sorry. So,
Go ahead.
Okay, there is one. Yep, no, there was one asking for the recording. So I do see the answer coming through now. I just want to make sure that this will be recorded and available on the AHAM website. And yes, Stephanie, I believe you are correct. The answer for the skip knowledge check was false, not unintentional. Sorry about that, guys. The false skips are clerical errors. And then, is that it? I think we did answer the statute of limitations question now. So, okay, I think we're good now, Maria. Sorry about that. I just wanted to make sure they all went answered.
No worries. Thank you very much, everyone. Have a great day. William, I'll turn it back over to you.
Great. Thank you so much, Maria. Before we sign off today, I would like to direct your attention to a survey that should appear right in the middle of your screen. If everyone could take a moment to fill out this brief survey, as AHAM does appreciate your feedback. And again, this does conclude today's session. To end, you may simply hang up or close out of your browser. We all hope you have a great rest of your day.